See, there you go.
See?
All right, well, just let me introduce myself real quickly. My name's Ed Parry. I've been practicing law probably since before most of you were born. I passed the bar in 1980. I was admitted in April of 80. So I've been practicing for a couple of years. And since about 86, 88, my practice has mostly revolved around collection law. And so when I was asked to talk here, we were talking about what collections, do we want to talk about regulation, do we want to talk how a collection lawsuit works. My first concern is that you guys probably know more than I do on a lot of stuff, because I have paralegals and they do all the hard stuff for me, and then I take all the credit. It works out really well, for me anyway. I'm not sure for them. So I just thought maybe what we could do is talk about the collection process a little bit, and then how a collection suit works from start to finish, and then talk a little bit about what you might have questions about. Does that sound like an okay way to deal with this? Great. So first off, let's talk about why did collections become an area of the law that's kind of distinct from others, or perceived as distinct from others? Anybody have an idea about why that would be? Volume, okay, which is interrelated, that's right. Basically, there are four types of collections that I could think of. There's domestic collections, which are the results of divorce decrees, support decrees, that type of thing. There are criminal collections, collecting fines, collecting
Restitution.
thank you. It's not that fun getting old. And the fees and stuff that are associated with that. There are commercial collections and consumer collections, which have a lot in common. There are some dissimilarities, but more similarities than dissimilarities in the consumer versus the commercial. So we can talk, mostly we're going to talk about consumer and commercial, because I don't know much about the other two. I know that the Office of Debt Recovery handles 90% of all criminal collections. Now, back when I started practicing, people were on their own as far as domestic collections go, which was really unfortunate. But over the years, the Office of Recovery Services has really expanded their role, or actually now, the decree is required to have the payments go directly to ORS rather than to the individual. So there's a lot better collection process there, a lot more in detail. Hopefully the system's expedited a little bit more there. Commercial, obviously, is just business related. And that doesn't necessarily mean, it could be a person that's a mechanic in their backyard, but if they're purchasing things or incurring debt on behalf of their business in their backyard, that's still going to be a commercial debt. And then consumer debt is primarily debt that's incurred for personal use, or personal, such as, utility bills for your house, or health care, that type of thing. And like I say, probably if you're looking at debt collection, consumer is going to be your biggest volume anyway. So the common fact, and there are three things that I looked at, and I don't know if you've got your devices or whatever, if you want to look at these. If you don't, it's no big deal. I've got them. I just printed them out for myself. There are three major areas that define what a debt is, because we're talking about collecting debts. So if you look at the collection agency statute, it says a debt means an obligation or alleged obligation to pay money arising out of a transaction for money, property, insurance, or services, which is a pretty good definition. The Consumer Credit Practices Act, which is 70C1201, says provides credit offered or extended by a creditor to an individual person, primarily for personal, family, or household purposes. The Family Expense Statute, which broadens some people's responsibility or liability, is it's basically the expenses of the family and the education of the children are chargeable upon the property of both spouses or either of them separately. which we'll get into. We'll talk about those two things a little bit more, the collection statute and the family expense statute in a couple of minutes. But let's just, now we kind of know what we're talking about when we talk about what a debt is. You guys know more. What would you look at if you were trying to collect a debt? What kind of things do you think would be important before you decided whether you wanted to, particularly to bring a suit on a debt? Yes.
Do they have income?
Okay,
Either
that's
from a job, from a 401k, Social Security, any kind of income.
okay. Good.
Assets.
Yeah. Okay. Good. How about where are they? I mean, you would be surprised at how big a factor that is in my practice. It's just, you know, they were one place when they got the service, but they're not there anymore. So being able to find them is important. Whether they have anything worth chasing is important. That's, of course, correct. What type of documentation you have of the obligation is helpful. If you've got a signed contract, you're in way better shape than if you just have an oral agreement, generally speaking. Not that the oral agreement's not enforceable, but again, the amount of the debt is quite often something that you want to think about. I don't know that a lot of well, depends on the case. We have a bottom line before, where we won't file a suit below a certain amount because it's just not cost effective. Yeah, I mean, if we have a $150 debt and we have fairly good information about them, but we're going to spend $120 in service and filing fee. We've doubled it without talking about attorney's fees. I'm a little uncomfortable finding I'm trying to collect 4 times what the debt is. Although if my client wants to bad enough, I will. The age of the debt, why would that be important?
Statute of limitations.
Thank you. Yeah, statute of limitations. If you've got an oral contract, you've only got 4 years to bring suit. Written contract, you have 6. Okay, and then the other, if you're a third-party debt collector, which is what my office is, and actually my main client is a collection agency, and they are as well, you also have to have certain things you have to do before you file suit. You have to send them an initial communication setting forth who the original creditor is, or that you can provide them information as to who the original creditor is. We always just put it in our letter. That they have 30 days in which to notify us if they dispute the debt, at which time we will validate the debt prior to bringing any other action, send them that validation. That's pursuant to the Fair Debt Collection Practices Act. If you're a primary creditor, those requirements aren't for you. But if third party, you've really got to worry about complying with the Fair Debt Collection Practices Act as well. If we really have time left when I'm done with this, we can talk about that a little bit, but it's a whole set. We could do 1,000,000 hours on just that, and I do on a regular basis. So how do you commence, let's say we've met that criteria. The debt's big enough, it's new enough, we know where the people are. It looks like we've got at least a handle on where there might be some assets that we can recover the debt from. What's the next step that we would do? And we've made our initial communication of our third-party collector. What would be the next thing we would do to get the lawsuit going?
Serve them with a 10-day summons.
Okay, that's one of 2 options, right? You commence the lawsuit. Rule 3 set of the Utah Rules of Civil Procedure. If I say rule whatever, know that this is the Rules of Civil Procedure we're talking about. Rule 3 says there's 2 ways to commence litigation. And you probably know what they are too. One's the 10-day summons, and the 10-day summons is a method where you can go ahead and serve them with the summons and a copy of the proposed complaint, and then you have to file the original complaint with the court within 10 days of service of the summons. They still have the 21 days to file an answer to the complaint, or to the summons and complaint. But it gives you an opportunity, if they're not there anymore, you've paid your constable to serve them, but you haven't paid the filing fee. And it cuts down a ton of the volume that the clerks would have to work with if you're filing cases if you're filing all your cases before you can serve them. So we commence the lawsuit by one of those 2 means. So it's commenced by service of the 10-day and then timely filing of the complaint. And that usually in our office anyway, and there are offices that vary on this, I won't request, even though it's been in my office for a while and we've done some work on it, we've tried to collect, we've sent out our initial communication, I will not charge any attorney's fees until such time as litigation's commenced. Now, even if the contract says no reasonable attorney's fees, and it doesn't specify when, and a lot of attorneys will say, well, I did this work, I'm entitled to be reimbursed for this. Just as a matter of practice for me, I don't do that. So we also trigger attorney's fees once the litigation's commenced. What happens next?
Wait for his answer or default.
Okay, right, something or nothing, right? If there's nothing, we get we look for a default. So after 21 days is run, we start evaluating how to go about doing a default judgment. If they file an answer, what's your next step?
Discovery or disclosures.
Okay, right, Rule 26 provides it now provide, which is crazy because you got a $130 case, I mean, worst case scenario, and you're doing Rule 26 disclosure, so you've got your initial disclosures, you've got to draft them all, you've got to list your witnesses, you've got to provide all the documentation that supports your claim, and you have to send it out to the defendant, and they're going to look at it and go, what that is this? And then in about 3 weeks, you're going to say, you know, we didn't ever get your initial disclosures back, you're required to give them to us, and we get a call saying, well, what is that? You say, well, we really can't give you legal advice, but look at the rule, and basically you see what we sent you, we want that from you on your side of the story. So you've got initial disclosures. Once we've got initial disclosures are exchanged, actually the plaintiff is required to file their initial disclosures within 14 days after they receive the answer. The defendant, I think, has 48 days from when they file their answer. Does that sound right?
It's a little less than that.
I think it's like 48 days from the answer or a month after plaintiff files theirs.
Okay.
I think, something like
Okay.
that.
I know it's a fairly long period of time comparatively. Okay, so let's assume they filed the answer. Let's assume we've done our initial disclosures. What can we do next? And it'll depend on what the answer says, obviously. What if the answer says, you're right, I owe the money, I just can't pay it? What would our next step be in that circumstance?
Pre-trial?
What?
Pre-trial?
In my office, if they say we owe it, we do a motion for judgment on the pleadings.
Okay.
But pretrial, that's on my list too. Usually if they're that easy though, we will do that because they've already acknowledged the debt.
And if they don't return their initial
Rule-
disclosures, do you move to strike their answer?
We used to. We have found now that the judges aren't willing to do that,
If they're pro se?
even if they're not,
Oh,
generally speaking. I mean, quite often, I mean, if we had a counsel on the other side, they'll just usually send us a letter after we send them our letter saying, we haven't got your disclosure, saying, oops, sorry, we'll get them to you. But generally speaking, when Rule 26 first went into effect a few years ago, that was a common practice, is if we didn't get them back, we filed a motion, because the rule is very specific. But judges have become less and less willing to follow the rule. Which I guess is understandable. I mean, you're dealing with pro se individuals, and they don't always know exactly what's going on and don't know that they need to find out. So 12C is motion for judgment on the pleadings if there's not an obligation. Also, Rule 56, motion for summary judgment, is another step you might want to take prior to setting a pretrial. Again, because if they say, I don't believe I owe this money because my insurance should have paid it, there's no question of fact. The fact is, that, well, we claim the money's owing. Yeah, we admit the money's owing, but we don't think we should have to pay it because we have a legal defense. Then a summary judgment might work for that in terms of, okay, Your Honor, here's the facts. Nobody argues about them. Here's what we believe the law is. Do you agree? Okay. Okay, and then if there's no resolution at that, I'm quite often, again, in consumer debt on the level that I'm doing it, we probably, if an answer is filed, probably 50%, maybe even more than that, we'll figure out a way to resolve it with a payment arrangement or a stipulation or something like that long before we have to do a pretrial on it. If we haven't reached any resolution, then we go set a pretrial. And two things usually happen at a pretrial. Again, the vast majority at the pretrial, they'll say, oh, you guys really are serious about this. Or they don't show up. If they don't show up, then the court will strike their pleadings and we'll get a judgment. If they do show up, one of two things happens. So I guess there's three things. The first is that they go, oh, I guess you're serious. Yeah, we really do owe this. We just can't pay it. And we try to make a payment arrangement and do a stipulation. Or they can send the judgment entering then, and then we're on our own to try to collect it. And the second is we'll set it for a trial. I'm not shy about trying cases, so we don't worry about that very much. Often tell them, and you guys are already well aware of this, but I usually just sit down and say, listen, what a trial is really is just, I get to tell the judge what I believe the facts are, you get to tell the judge what you believe the facts are, the judge then tells us what the facts are, and then applies the laws to the facts as he sees them, which is, you know, works pretty well, as at least an explanation is to them. I don't know how many of you actually are involved in debt collection all the or on a regular basis? Obviously you are.
I certainly
You are, I know you're kind of on.
I'm not.
Yeah. Okay, you are a little. Okay. One thing we get a lot is people writing in saying, well, we offered you $10 a month and you're obligated to take that off. You're obligated to make that arrangement with me. Any veracity to that? Yeah, I don't see any consideration. I don't see any meeting of the minds. But seriously, people believe that the law tells them that they can dictate the terms of their repayment. So, just something that I think is interesting. I agree.
I've had clients say, well, I'm going to take it to court, and the court will tell you what to accept.
Yeah. And we say, it doesn't work that way. Okay. So after the trial or after judgments obtained by any of those other sources that we've talked about, you notice I'm so positive after the trial, so we have judgment after that. It doesn't happen very often that we don't. Is then how do we collect the money? I mean, this is all great stuff and it's perfect, but we haven't accomplished anything yet, the purposes of what our job is. So how do we go about trying to collect the money?
Civil matter proceedings.
Garnishment? So actually there's a statute that was passed about, I want to say 5 years ago, maybe a little longer than that, where you can actually petition Department of Workforce Services and find out what their current employment is according to their records. So we'll quite often do that if we don't know where they work. What?
I said, that helps.
Yeah. Well, not as much as you would think.
Just
But
to
it does
find
help,
out,
yeah. But at least you know where they're not working after you thought they were or whatever. Or you know where they were working at one time, kind of work your way forward from there. But that's one way. So garnishment of wage, if you know where they're working, that's great. You get garnishment, you get 25% of their net, as long as they are above the floor set forth in Rule 64D, sorry, which is, I want to say $7 an hour, 30-hour a week. If I remember right, might be. Anyway, there's a floor. They do the math, and I smile when I get the check. Another way, again, is a payment arrangement. We're never adverse to not spending more money of our clients than we have to. So if they call in and say, okay, you've got this judgment, how about we do this? Quite often that'll work. They'll say, yeah, you know, we've got this judgment now, but if you can pay it off over 6 months or 10 months, we'll do that. Depending on the size of the judgment. If it's one of those $150 cases, maybe not 12 months. There's two types of garnishment. There's the wage garnishment, which we've talked about a little bit. And then there's a non-wage garnishment, which is where you're attaching bank accounts. If they're a 1099 employee, or so they're not an independent contractor, the person that they're providing services to, you can use a non-wage garnishment for them as well, and actually attach what they're owed for that period. So they don't get the 25%, you get 100%. Okay, so we've done that. What type of objections are there to garnishments that can be raised?
Previous garnishments.
What?
Previous garnishments.
Okay, that's good.
Exempt income, some income's not garnishable, right?
Correct. Okay, so that's one. So you were mentioning, do they have Social Security and whatever? Social Security is not attachable by garnishment. pensions are not attachable, unemployment's not attachable. There's a whole, child support and alimony are not attachable. Those are the big ones that we see on a regular basis.
But Social Security is attachable for child support.
Right, that's true. That's true, but again, I'm talking about
You're
my
right.
experience. I don't think about what other people can do, because, you know, the Office of Recovery Services that does the criminal stuff has a lot broader scope than I do. ORS can garnish up to 50% of their net, not 25% as well. So, and some people tell me it's way more than that, but I think they don't realize that their net doesn't include what comes out for insurance and comes out for some of the other things that are coming out, so they don't see that as part of their check, but it's not taxes, which is all that's really taken out before you do the factoring on the computation. One of my favorite experiences, and this goes back a little ways now, is I had a gentleman file a objection to a garnishment. We went into court, and he argued that, it was a non-wage garnishment. We'd gone in there, he said, no, you took the money out of my bank account. I was intending to pay my child support out of that money. And he thought that was a great argument because it was, in his mind, at least theoretically, it was earmarked for that. And the judge wasn't very convinced that that was the case. I certainly wasn't. But people have these really interesting ideas as to how they what they should be liable for and what they shouldn't, and what we should be able to do and what we shouldn't. I guess my ultimate favorite is the people that I had in on supplemental order, and we'll talk about those in just a sec too. And they said, well, you know, really, we admit that we used our card to take this trip, and we took the trip, but we didn't have as much fun as we thought we were going to, so we shouldn't have to pay. So that's basically, if I ever write a book, that's going to be the first chapter. So anyway, that's where okay, so if we don't know where they're working, we've talked about attachment. If we don't know where they're working, how do we find information out about where they might have assets?
Supplemental proceedings. Supplemental proceedings?
Exactly, okay. So basically there's a process where after you obtain a judgment, you can serve an individual with what's called a motion to order in supplemental proceedings, bring them into court, and you can quiz them about their income and their assets. That's what I was doing in Price and in Richfield the last 2 days. And basically I have just a stock questionnaire. We ask them for their name, where they're currently living, their social, date of birth, where they bank, where they work, who they rent from, what vehicles they own, who they owe money to on the vehicles, where they bank. I already said that, sorry. What if they own any real property, if they own any personal property that has inherent value. Although again, if I were just starting to practice now, I wouldn't know this was a problem because it would just be the way it's always been. But after 38 years, initially when I started practicing, you could do a writ of execution and basically have the writ of execution, you could send it to the sheriff, they would take it, for example, to a business where you have a judgment against a business, and they would just say, we're going to attach everything you've got here. Well, the courts over the period of the 30 years have now said, well, unless you can identify specifically what assets are there that you want the sheriff to attach, they can't attach them. And so writs of execution, I won't do them anymore. They don't have any value to me. But that's a possibility. And so we still ask the questions. If nothing else, maybe it motivates them into thinking that they ought to pay us. So we go through that. If they don't show up for a supplemental order, the court will issue an order to show cause saying, come in and tell us why you didn't show up for the first order we told you to come to court. If they don't appear for that, quite often the court will issue a bench warrant. Again, not because they owe the debt, because we don't do debtor's prison here in the States, but because they failed to comply with the court order. And they are required to either post bail and then show up, or the bail can be forfeited if they agree, or sometimes if they don't. And so and then once you've got that asset information, and then you go back to what we were talking about before. We look at garnishments, non-wage garnishments, attaching property, and so on. How many of you have ever heard of a judgment lien? Okay, so you know what those are basically. Did you know that until 2002, those were automatic if you got a judgment in district court? I know.
Very helpful.
It's really sad, isn't it? So up until then, literally, you could do a judgment lien just by getting it. If you had a small claims judgment, you could abstract it to district court. It would automatically make it a judgment lien. And if you had it in district court, that was just it. Now, the advantages of a judgment lien, if they own real property, obviously if they don't, there's not one. But if they own real property, it gives you an interest in that property. And what's interesting about that interest is then they can't, if they want to sell their property, they're going to have to take care of you before they can, because you've got a cloud on their title. If they want to refinance, same situation.
Sometimes they don't even know they have a judgment lien until they try to sell.
No, that's exactly right. As much as we've tried to encourage them that they do, or that they should. And so we file those on anything that looks like they might have. We usually also will check to see if they own real property before we commit suit. Also really would restrict their ability to purchase property without taking care of it, which doesn't make a lot of sense, except for if they purchase the property, I could at least think we could make the argument that the judgment lien attaches to the property they subsequently acquire. Now that's maybe ex post facto and maybe wouldn't work, but I would argue that if I had the chance. I just haven't had the chance yet.
I have a question about privacy, because we in law firms have access to a lot of different records electronically, and we're not allowed to go search out people without a valid reason behind it. So like,
Okay.
I'll do property searches all the time.
Right.
Because that's a public record.
Correct.
And I'm doing it for clients. But I knew that there are like other sides, like maybe Department of Motor Vehicles. There's other sites out there that I was under the understanding, if you had a legitimate reason, you could go electronically search people. True? Not true anymore?
Well, DMV not so much. You have to have a written order almost to get that information
Now?
from them, to the best of my knowledge.
Mhm.
Like I say, there's a statute that says workforce services will provide information if you meet certain criteria. But you have to show them you already have a judgment, you have to have a social for them and whatever, and you have to pay them like a $25 fee.
Mhm.
And then you get the information from them if they've got it.
So you
But-
guys don't ever just start electronically? You file the paperwork?
What do you mean by start electronically? Sorry.
Well, just access to personal information because you have accounts with different organizations because you're a law office.
No, and in fact, back in the day, you used to be able to do that with the credit bureau all the time.
Yeah, maybe that's one of them that I was thinking.
And-
I just know that
And you can't do
we've been
that, and you
told,
can't do that anymore, for
we've
sure.
been told for a long time that
Yeah.
without a legitimate reason behind why you would search a person.
Right, you can't
go
just put
searching.
somebody's name in and see what.
Yeah, you can't say, oh, my
Who else they were,
girlfriend's
where they're
dating this
working or
guy,
whatever.
let me go see what
Exactly,
he's like.
exactly. And in fact, unless you've got a specific reason that's personal to your client, the credit bureaus won't give you anything anymore. Unless, because if you're extending credit possibly, but if you're trying to collect,
Okay,
that doesn't fit in.
okay, just
So,
curious.
oh, it's a good question, thank you. My favorite thing, the other thing that's interesting is that, we're still with judgment liens for a minute, or going back to them, I don't remember where we were, is that if you have a judgment lien and the individual files a bankruptcy, while the underlying debt is discharged, the judgment lien remains in place.
They have to strip it.
Unless they've either filed a motion while they were doing their bankruptcy to avoid your lien, it's still there. We get calls from title companies all the time saying, we show this judgment lien, the bankruptcy was filed. We say, that's great. We're not actively trying to collect this debt. We understand it's discharged, but we still have a security interest in this property. And usually what I will do is just tell them, well, I'll tell you what. It would cost your client X number of dollars probably to go back to their bankruptcy lawyer, have him reopen their bankruptcy, have him file a motion to avoid my lien, get the order, and then you sell the property, or pay me X and we'll release the lien. It's not a violation of the automatic stay because we're not trying to collect the debt, we're just releasing our lien in exchange for consideration. So that's another good thing for, on a judgment lien that's helpful, that picked up as we went along. Yes?
How many of your cases filed for bankruptcy were with the
Oh my
lawsuit?
God.
I'm just curious.
And I couldn't even give you a number, but the percentage is actually way lower than I think it would, I would have
Really?
thought it would have been. We get threats to file all the time, but it actually requires people to do something, and so quite often, that's the second step that they don't follow through on.
That's most of my experience is bankruptcy, so.
Is it? Okay.
See that
But, you know,
aftermath.
actually, we just don't have a huge percentage that file.
Really?
We probably have, I mean, if I had to guess, I'd say maybe 15 or 20%. It may
I
not
thought
be
it'd be
that
much
high.
higher.
Yeah,
I was thinking when I did foreclosures, about 30% would file 5 minutes before the sale.
well, yeah, that's,
About it, yeah,
and I do
Or
some
that they're
foreclosure
losing.
work as well, and
Yeah.
that's very common.
yeah,
And then it's dismissed, and then you reset your sale.
yeah, pretty much.
Okay,
But it is a hassle to file bankruptcy. So
What?
it is a hassle to file bankruptcy.
Correct.
So people, going to say, okay, well, I'm just gonna file bankruptcy, and then they go and say,
oh,
They have a
no,
lot to do
this
to
this
file
wasn't what I
bankruptcy.
thought it was.
yeah.
I thought it was a magic bullet.
Yeah. So that's probably why.
I
they don't
think,
get
I
followed.
think you're right, I think that's a lot of it. Okay, now, how long is your judgment good for?
7?
You're close.
8.
8 years, okay. And after 8 years, what happens?
You get to renew.
What?
Get to renew.
Okay, you can renew. The renewal is set forth in Rule 58C, and you have to jump through a bunch of hoops, and your client has to say, okay, and you have to send out a motion to renew, and you send it delivered to defendant, and you have to show that you've made at least, well, in American Fork, you have to do more than most, any other court in the state. In American Fork, you have to prove that you made every effort to try to locate what their new address is, even though they're obligated to keep the court informed of what their address is. Most other courts, as long as you say, well, we've done everything we can to find their address, we did a new LexisNexis search, we've done everything else for them, to the best of our knowledge, this is the last address we have for them, that's sufficient. But then you renew it, it's good for another 8 years. If they pay, what do you do?
I mean, they release, right?
You release the lien, and you satisfy your judgment, right? And that's 58B, says you have to do that, and I think it says you have to do that within 15 days of getting the payment. I should have looked, but I forgot to, I just looked up the rule. Okay, so let's talk a little bit, unless you've got specific questions, let's do those next. And then we can talk a little bit about the Fair Debt Collection Practices Act, which deals only with consumer debt. Any other questions about just the nuts and bolts? Like I say, I always hesitate to talk to a group like this because you know more than I do about 90% of this stuff. Okay, well then.